Hello everyone, it's day 65 and today I have May 7th, 2024 Indian Express newspaper and as usual I have explained page and there are two important articles which I have found to be worth reading. One is about the Muslim quota question which is written by Faizan Mustafa, well-known well-known constitutional expert, and another is about the Boeing Starliners which is about to launch. So let us see both of these articles one by one. So first article, it is about the what is the history of religion based reservation, how have various states tried to include Muslim with reserved categories, and how have the courts ruled on the quotas for Muslim communities. So in election season, India is debating fundamental constitutional question around reservation. Can a secular country like India have religion based reservation? Have Muslims ever been given reservation by reducing the quota of scheduled caste, scheduled tribe, and other backward classes? Does reservation for SCs, that is limited to only certain religious denominations, amount to reservation based on religion? So let us see. Reservation and constitution. The Constitution of India moved away from equality, which refers to equal treatment for all, to equity, which ensures fairness and may require differential treatment or special measures for some groups. So the Supreme Court has ruled that equality is a dynamic concept with many aspects and dimensions, and it cannot be cabined and confined within the tradition and doctrinaire limits. So it was in EP Rayappa versus State of Tamil Nadu in 1973. So the normal equality is concerned with the equality of treatment, treating everyone the same, regardless of outcomes, which can at times lead to serious inequalities for historically disadvantaged groups. So substantive equality, on the other hand, is concerned with equality of outcomes. Affirmative actions promotes this idea of substantive equality. The Constitution of 1949 dropped the world minorities from the Article 296 of the draft Constitution and Article 335 of the present Constitution, but included Article 16, Clause 4, that enabled the state to make any provision for reservation in favor of any backward class of citizen which is not adequately represented to the services under the state. The first constitutional amendment inserted Article 15, Clause 4, which empowered the state to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. So, Article 15 especially prohibits the state from discriminating against citizens on the ground only of both religion and caste, along with sex, race, and place of birth. So, after the Supreme Court's judgment of in State of Kerala versus N.M. Thomas 1975, reservation is considered not an exception to the equality, non-discrimination clauses of Article 51, 15 Clause 1, and 16 Clause 1, but as an extension of equality. The crucial word in Article 15 and 16 is only, which implies that if a religious, racial, or caste groups constitutes a weaker section under Article 46 or constitutes a backward class, it would be entitled to special provision for its advancement. So, some Muslim castes were given reservation not because they were Muslims, but because these castes were included within the backward class, and reservation was given without reducing the quota for SC, STs, and OBCs by creating sub quota within the OBCs. The Mandal Commission, following the example set by the several states, included a number of Muslim castes in the list of OBCs. The Supreme Court in Indra Sani in 1992 let down that any social group, whatever its mark of identity, if found to be backward under the same criteria as others, will be entitled to treat it as backward class. So let us see Kerala Muslim subquota. Religion based reservation was first introduced in 1936 in Travancore, Cochin state. In 1952, this was replaced by communal reservations. Muslims, who constituted 22% of the population, were included within the OBCs. After the state of Kerala was formed in 1956, all Muslims were included in one of the eight sub-quota categories, and a sub-quota of 10%, down 12%, was created within the OBC quota. Unlike the faulty report of the Mandal Commission, which concluded on the pattern of Hindus that only 52% Muslims over OBCs in Kerala and Karnataka from the times of Maharajas, Muslims were seen as having been drawn overwhelmingly from the untouchable and the low and the other low caste, and were thus included among the backward classes. So, Karnataka's decision. The third backward class commission of Karnataka, headed by Justice O. Chinnappa Reddy in 1990, found, like the Hanuvar 1975 and Venkata Swamy 1983 commissions, that Muslims fulfilled the requirement for being considered among the backward classes. In 1995, the government of Chief Minister H.D. Devagowda, who is currently an ally of the BJP, implemented 4% Muslim reservation within the OBC quota. 36 Muslim caste and which are part of the central list of the OBCs were included in this quota. So Devgowda's JDS had criticized the decision of Basuraj Bommai government to scrap the Muslim quota before the assembly polls of 2023. The Supreme Court subsequently stayed the Bommai government decisions. Tamil Nadu backward Muslim. The government of M. Karunanidhi passed a law in 2007 based on the recommendation of the Second Backward Class Commission, headed by the J. A. Ambanskar, 1985, that provided within the 30% OBC quota a subcategory of Muslims with 3.5% reservation. This did not include upper caste Muslim. The act gave reservation to some Christian caste, but this provision was subsequently removed on the demand of Christians themselves. So Andhra Pradesh and Telangana, the question of giving Muslim reservation along with 112 other communities caste was referred to the Andhra Pradesh Backward Classes Commission in 1994. In 2004, based on a report by a commissioner of minority welfare on the social, economic, and educational backwardness of Muslims, the government provided 5% reservation, treating the entire community as backward. So the High Court struck down the quota on the technical ground that the mandatory consultation with the AP Commission for backward classes was not done. It also held that the minority welfare report was bad in law because it laid down no criteria for determining backwardness. It was in T. Muralidhar Rao versus State of AP to Andhra Pradesh 2004. However, the court held that reservation for Muslim or sections groups among them in no manner um, militate against secularism, which is part of the basic structure of the constitution. Relying on M.R. Balaji versus State of Mysore 1962, the court noted that Muslims, or for that matter Christians or and Sikhs, etc., are not excluded for the purpose of conferring the benefits under Article 15 Clause 4 or 16 Clause 4. In M.R. Balaji, the Supreme Court observed it is not unlikely that in some states some Muslims or Christians or Jains forming groups may be socially backward. This is why, though caste in relation to Hindus may be relevant factor to consider in determining the social backwardness of groups or class of citizens, it cannot be made the sole or the dominant test in that behalf. In Indira Sani 1992, the Supreme Court held that in a particular state, Muslim community as a whole may be found socially backward. As a matter of fact, they are so treated in Karnataka as well as Kerala. Following the 2004 High Court decision, the Andhra Pradesh government referred the issue to the Backward Class Commission. In 2005, based on the Commission's report, the state promulgated an ordinance declaring the entire Muslim community as backward and provide 5% quota. But the High Court struck down the ordinance in B. Archana Reddy versus State of Andhra Pradesh 2005 on the ground that the benefit could not be extended to the whole community without proper identification of social backwardness of Muslims by the Commission. The five judge bench of the High Court reiterated that there is no prohibition on declaring Muslims as a community socially and educationally backward, provided they satisfy the test of social backwardness. Thus, the failure of the Commission to recognize the heterogeneity of Muslims became the basis for the rejection of its report and of the ordinance based on it. The state again referred the matter to the Backward Class Commission and, based on its report, enacted a law in 2007 giving reservation to only 14 Muslim castes such as washerman, butcher, carpenter, gardener, barber, etc. Similar occupational caste of Hindus were already in the list of backwards and enjoying reservation. The schedule of the act explicitly excluded 10 higher castes among Muslims such as Sayyid, Mushaq, Mughal, Pathan, Irani, Arab, Bora, Khoja, Kuchi, Memon, etc. But this act too was struck down by the High Court. The final word on its constitutionality is awaited from the Supreme Court. After the bifurcation of Andhra Pradesh in 2014, the TRS government in Telangana passed a law in 2017 proposing 12% reservation for OBC Muslims on the basis of reports of the G. Sudhir Commission and the Backward Classes Commission. The Sudhir Commission found that in educational attainment, work participation, and household level possession of land, Muslims were behind SC/STs and Hindus in general. Since the proposal would take reservation beyond the 50% mandated by the Supreme Court in its Indira Sani judgment 1992, it was referred to the central government for inclusion in the ninth schedule, but the center did not bring the proposal to parliament. So the Sachar and Mishra panel, the Justice Rajinder Sachar committee in 2006 found that the Muslim community as a whole was almost as backward as SCs and STs and more backward than non-Muslim OBCs. The Justice Ranganath Mishra Committee in 2007 suggested 15% reservation for minorities, including 10% for Muslims. So, based on these two reports, the UPA government in 2012 issued an executive order providing 4.5% reservation of minorities, not just Muslims, within the existing OBC quotas of 27%. Since the order was issued only a few days before the assembly election in UP, Uttarakhand, Punjab, Goa, and Manipur, the Election Commission asked the government not to implement it. The Andhra Pradesh High Court quashed the order, and the Supreme Court refused to stay the High Court's order. So, the Article 341 of the Constitution and 1950 Presidential Order state that only Hindus are entitled to be inclusion within the SCs. However, Sikhs were included within the SCs in 1956 and Buddhists in 1990. So, Muslims and Christians remain excluded. It could be argued that this too is a religion based reservation. So, after that long article, let us come to the SFG, Six for Justice, and its alleged link with the Aam Aadmi Party. So that Delhi Lieutenant Governor VK Saxena on Monday recommended a national investigation agency probe against jailed Delhi Chief Minister Arvind Kejriwal for allegedly receiving political funding from Six for Justice, a New York-based pro-Khalistan organization that is banned in India. Sources in the LG House told the Indian Express that the recommendation was made based on the complaint by Osho Mongia of the World Hindu Federation, a diaspora-based Hindu advocacy organization. Mongia alleged that Kejriwal's Aam Aadmi Party received $16 million from Six for Justice for facilitating the release of Devendra Pal Bhullar and espousing the pro-Khalistani sentiment. So the ballots, not bullets. So Sikh for Justice was founded in 2007 by Gurpatwant Singh Pannu, a US-based attorney who is currently in his late 40s. According to its website, Sikh for Justice seeks to achieve a self-determination for the Sikh people in their historic homeland in the Indian-held Punjab and establish a sovereign state popularly known as Khalistan. So it was formed with the overt recognition that the wanton that the wanton of use of violence had been the Khalistan movements are Chile's heel. So Terry Milevsky, Canadian journalist and the author of the Blood for Blood 50 years of the global Khalistani project, had previously told the Indian Express Pannu's motto was ballots, not bullets. Thus far, SFJ's most notable activity has been so-called Referendum 2020 for the secession of Punjab, especially the Indian state and not the Pakistani province, held among the Sikh diaspora in some cities. So the rules and identification requirement are partial. Milevsky told the Indian Express, "I have friend in London who lodged an online who lodged on online to register to vote, put down Angelina Jolie as his name, and was successfully registered for the vote." So, how it is banned in India? India refers to Pannu as a terrorist and has banned SFJ under the UAP Act of 1967. The Home Ministry 2019 notification issuing the ban says, in the garb of the so-called referendum for 6, SFJ is actually espousing secessionism and militant ideology in Punjab while operating from safe havens on Punjab soils and actively supported by inimical forces in other countries. So currently almost a dozen cases are registered against Pannu and SFJ in India. So that's all about important articles from today's newspaper. One was very important regarding the constitutionality of a law that is passed recently in Karnataka. So this is news in transition. We'll see in subsequent edition about the issue. So till then,